Hi everyone. I decided to make a little additional video in response to the overturning of Roe v. Wade that occurred in June of 2022. Historically, I don't talk about Roe v. Wade or anything having to do with the laws or the regulations surrounding abortion. In this class, I try to just talk about the process and the decisions that can go behind it. But given the current context, I just thought it would be really helpful to talk a little bit about abortion historically and how it is going forward as things stand right now. So just to get us a little bit into like where abortion was prior to Roe v. Wade, I think there's a lot of misunderstandings and misinformation surrounding what the abortion landscape looked like before Roe v. Wade. That occurred in that judgment came down in January of 1973. So before that, here's a map of the United States prior to Roe v. Wade, and what you'll see is that different states had different laws regarding abortion prior to the Supreme Court in 1973 saying that the state doesn't really have the right to tell a woman, what medical decisions to make with her doctor. And so what we can see is that a lot of the states are red, which means that abortion was legal in cases where the pregnancy was a danger to the woman's life. So all the red states have that as part of it. And in fact, all the orange, yellow, blue, that's all implicit as well. So all the states except for Pennsylvania had abortion legal prior to, as of at least 1972, abortion was legal if it was a danger to the woman's life, not psychological health or something like that, but specifically to her life. In 1967, Colorado was the first state to extend that and say that it was legal to perform an abortion in cases where it was a danger to the woman's health, or if the pregnancy was the result of rape or incest, or if there was likely a damaged fetus. Now, part of this came from a case in Arizona where a woman had, and she was a very famous woman. When back in the olden days, there was a show called Romper Room, and this woman was the host of Romper Room, and she already had, I think at that time, 2 or 3 children, and then she became pregnant, and with a wanted child, but she was having really bad morning sickness. And so her husband, who had made a trip to Europe, brought home this anti-nausea medication called thalidomide, and she took the thalidomide to help with her morning sickness, and it was later discovered that thalidomide caused significant abnormalities, absence of limbs, things like that. And so there was no such thing in those days as ultrasound or any way to find out whether this particular fetus had any of these abnormalities, but she wanted to have an abortion because she didn't want a child with physical abnormalities, and she was unable to get an abortion on those grounds. And in fact, as the host of Romper Room, the whole thing was in the media, and she ended up going to Sweden and having the abortion performed. So part of the motivation in Colorado to codify this was a response to what had happened to this case in Arizona. And so they extended it out to not just danger to the woman's health, but also rape and incest or a likely damaged fetus. In 1973, more states added abortion rights, and that's Hawaii, New York, and Washington. And these were even broader than what Colorado had brought, and these were laws that said abortion was legal at the doctor's discretion. So this was the beginning of cases where states were making decisions that were allowing abortion. Other states were making decisions that were disallowing abortion, that were barring abortion in the case of Pennsylvania in all cases. Like I said, in the red states, even as it is today, even in the states where you're being told that there is no more abortion, abortion continues to be legal everywhere if the woman's life is in danger. So that's a little bit of a red herring that you might be hearing in the news, that a woman with an ectopic pregnancy can't get an abortion. That's not true. In all of these states, a woman who has an ectopic pregnancy can get an abortion, because that's a danger to her life. In most of our states, we have, variations. And so what you're going to see is, if you look at, I always get Mississippi and Alabama mixed up, so I have to stare at them for a second. But okay, so Mississippi is the one on the left, and it's as of prior to 1973, abortion was legal in the cases of rape. And then, but Alabama, it was just danger to the woman's health. So health is different from danger to the woman's life, right? So health would be looking at things like reproductive capability in the future, or, other kinds of damage that might occur that wouldn't kill her, but would, have an impact on her ongoing health. And so, so in Alabama, it was a little bit more than what the red states had. The red states said if it's a danger to your life, then you can have an abortion. In Alabama, they said if it's a danger to your health, you can. And Mississippi said if it's a case of rape, that you can. So there were variations around the nation, and all the yellow states are states where they said it's legal in cases of danger to the woman's health, or if it was rape or incest, or if the fetus is damaged. So these are all prior to 1970. I just heard a story from one of my colleagues about somebody that they knew when they were in college who had a pregnancy. They were in Ohio, and it was an unplanned pregnancy, and they wanted to have an abortion, and there was no place to go in the United States, the story was being told. And so they flew her to London to have an abortion. They couldn't afford, they had gotten money together to fly her to the abortion in London. They didn't have enough money to put her up in a hotel for the night, so she had to immediately get back on the plane and come back. The problem with that story is that New York is much closer to Ohio than London is, and it doesn't involve, airfare and all these things. And so I was a little perplexed by the story, because it implied that there was no place to go in the United States where you could get an abortion. And given my colleague's age, I'm guessing this happened after 1970. So there were a lot of places that could have, for sure, Washington and New York by 1970 could have accommodated. I'll give you Hawaii and Alaska are just as bad as going to London. I'll give you that. But anyway, so something else I wanted to mention is funding for abortion for low-income women. Washington has been on the forefront of that as well, where the state mandates that Medicaid can cover medically necessary abortions for low-income women. Other states, the lighter blue, say that Medicaid covers medically necessary abortions for low-income women under court order only, like they've been told that they have to do it. But in the dark states, which are Washington, New York, and Maryland, those states, their state legislation says that Medicaid dollars can be used for it, so they don't have to be told by the court to do it. So that's a point of contention for a lot of people, using federal dollars, using taxpayer dollars to pay for something that some taxpayers ardently believe is immoral or wrong. And so it's one of those points of contention surrounding this topic. So Roe versus Wade came along in January of 1973, and what the Supreme Court of the United States declared is that the right to privacy, which is in the Constitution, covers a woman's right to obtain an abortion, because the state doesn't have a specific interest in regulating that. It's not part of their power to regulate that. And in this decision, it established the first 12 weeks of pregnancy as the threshold for state interest. So basically, abortion prior to, during that first 12 weeks of pregnancy could not be banned. And so you may have heard in the last few years some states offering laws that said, abortion is banned after 12 weeks, or abortion is banned after 8 weeks, or abortion is banned after 6 weeks. That's when it started to get into that area where Roe v. Wade was saying, no, you can't make laws that prohibit abortion prior to the 12th week of pregnancy. Like those first 12 weeks, the states cannot limit access. The states were allowed to impose increasing restrictions or outright bans later in pregnancy. The way that SCOTUS said it was, unless it's necessary to preserve the life or health of the mother, even if it would cause the demise of the viable fetus. So they couldn't, the Roe v. Wade decision did not say that abortion was legal throughout pregnancy. It said it was that the states could not limit access for the first 12 weeks, and that they could limit access after 12 weeks as long as they weren't putting limits in place that would put the mom's life in jeopardy, the mom's life or her health in jeopardy. Even if that meant that to save mom's health and life, the fetus had to die, the mom was given preference in that decision making. So a lot of people have mistaken what Roe v. Wade said as being like abortion on demand throughout the pregnancy, and that's not what Roe v. Wade said. In 1992, in a Planned Parenthood versus Casey case, there was actual further clarification. Basically, what the Supreme Court said is that women have a right to choose to have an abortion before the point of viability. And so it went from 12 weeks to actually the point of viability would be the point at which women could no longer make that decision sort of without a medical need. Today, in summer of 2022, as I'm recording this, the viability is approximately 23 weeks. I say approximately because there are a lot of variables that go into the likelihood that a fetus would survive outside of its mother. It varies, for one thing, based on the sex of the fetus. Female viability is earlier than male viability. It's probably more like 22 weeks for female fetuses, more like 24 weeks for male fetuses on average. Males' lungs don't develop as early as females do. And so that's the thing that is the most likely to fail in a premature birth. And so, we have sex differences on the age of viability. As the point of viability has dropped from about 28 weeks in 1973 to what it is today, the cutoff has become the subject of debate, because when you use something that moves like the age of viability, it's not a clear order about the legality of the situation. So that has been a point of contention. Now, the case that occurred in June of, or the decision came out in June of 2022 was Dobbs versus the Jackson Women's Health Organization. And what the Supreme Court said is that the Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision. And they said that we hold that Roe and Casey must be overruled. It's time to heed the Constitution and return the issue of abortion to the people's elected representatives. So what the Supreme Court ultimately said is that legislation needs to determine what the law is on this. You can't just have the Supreme Court ruling on what the current Supreme Court says is not a constitutional provision. It's not in the original Founding Fathers written Constitution. If you want it to be a law, you have to make it a law. And so that's what they basically kicked it back to the states. And so we're back to states having individual laws about that. So this map comes from a website that is that kind of pulls these things together. You've seen other things that I've used from Guttmacher throughout this discussion prior to this video. So they color-coded the states following the overturning of Roe v. Wade into the most restrictive states being, the dark red, to the most protective being the dark blue. And so they went for a balanced gradation here. So they have a category called very protective, and none of the states are actually in that category. So most protective, they're referring to protective of the right to choose. The most restrictive is meaning the most restrictive on the right to choose. And so you see that, Texas, Oklahoma, Arkansas, Missouri, Mississippi, Alabama, and South Dakota are the most restrictive, which is kind of funny because remember I showed you that map from prior to Roe v. Wade, and Mississippi and Alabama had among the most liberal laws back then. So it's kind of an interesting switch that now they're being characterized as the most restrictive. So you see that a lot of states are in the category that Washington is in, where it's considered protective. And so I thought I'd share with you what it says, according to this website, that Washington does that makes it in the category of protective. Most of these states have a ban on abortion after the point of viability. The generally accepted age, 24, 26 is the case in Washington. There are a few states that are more liberal than that. For example, California doesn't have an end point on abortion on demand. So different states have different rules about that. Prior to Roe v. Wade overturning, California couldn't implement that abortion on demand because part of Roe v. Wade said that you couldn't do it on demand after the point of viability. So in certain ways, in certain states, the laws have gotten broader now that Roe v. Wade has been overturned. So Washington is considered protective of abortion rights because it allows abortion on demand up until 24 to 26 weeks of pregnancy. It allows state Medicaid funds to cover abortion. It requires, if the person is covered by private health insurance, that health insurance has to pay for the costs of abortion. In the state of Washington, qualified health professionals, who could include nurse practitioners, physician's assistants, so on, not strictly just MDs, can provide abortions. In some states that are characterized as more restrictive, one of the factors that goes into that is that they require physicians to perform abortions. And then finally, in Washington state, one of the things that makes them protective is that there are protections for patients and abortion clinic staff at clinics. There are rules about having to be far enough away from the entrance of a clinic for any kind of protesting, or like what can be said to people who are going into the clinic and things like that. So this is the constellation of characteristics of Washington's rules that makes it considered more protective rather than restrictive. Oregon has the most protective laws, and it has, abortion on demand throughout the pregnancy. It has Medicaid funds covering abortion. Like, it has all of this and more. So different states have made different decisions about how they would like this to go. And, public opinion polls in different states show that different the residents of different states do in fact have different attitudes about this topic. A lot of people are presenting these different states' rules as if they're being imposed on their populace, rather than these are people who were elected by their population because they perhaps share their views. So we have to be really careful about imposing our viewpoints on other people, and be aware that people do vary on this topic, and the full spectrum of attitudes. Some people think it should never be allowed, even in the cases of rape and incest, because it's a life and it's not the baby's fault. Other people look at it the other way and say the mom is primary and why should she have to? And there's a lot of different ways to look at these things. And so the reason why I typically don't cover these details in my class is because it's a hot button issue that kind of takes away from my intent in this class, which is to help people have the information that they need to be able to make good decisions that will help them to have good sexual hygiene across their lives. Some things I've been hearing in the media, though, have made me want to talk about this at a different level. For example, I heard a case where they claimed that they couldn't get an abortion for their ectopic pregnancy. For one thing, they don't perform an abortion in the case of an ectopic pregnancy. An ectopic, as I've already covered, or maybe it's coming up next, because I'm sticking this in the middle of a playlist. In an ectopic pregnancy, you have an implantation that is not in the uterine lining. So it's not going to develop. It's not going to be viable. A lot of times it's in the fallopian tube, and it's going to burst the fallopian tube. And typically there's not a lot to be done about it. You don't get an abortion. It sort of resolves itself, and with great pain, and sometimes with a loss of some degree of fertility as a function of that. If there is an ectopic pregnancy that's close enough to the uterus, but it's not in the uterus, they may do a version of an abortion, probably a medical one where they give you the medication to trigger the abortion. But it's not. In none of the 50 states is that prohibited. That is a medical treatment that it's not a viable fetus anyway. So it's an embryo. Maybe it might even still be a blastocyst at the time of the procedure. And so that's a completely separate thing. There was a case that was in the news recently where a 10-year-old was raped by an adult, became pregnant, and this was again in Ohio, and the story goes that they had to take the child to Indiana because they couldn't get an abortion for the child in Ohio. Well, Ohio has a set aside for cases of rape. I mean, you have a 10-year-old child, this is clearly rape, statutory rape in this case in the minimum, let alone whether it might have been a forcible rape. And so that child could have had an abortion in Ohio, but it was used as a case to say, look, we had to take a child across state lines and like that. It's just being discussed in a way that is not super helpful for good decision making. So I feel like it's really important for the purposes of my class for all of us to be focusing on how to make a good decision about maybe how we want to vote in our own state in the future, or what our options are if we find ourselves in the situation of an unplanned pregnancy or a pregnancy that was wanted, but there's factors that make it impossible to go full term, these kinds of things. So that's what I wanted to emphasize. And I really wanted to show you this map and show you that, yeah, there are some states that are being very restrictive. And in some states, it's an all-out ban. Some, it's an all-out ban except for rape and incest. I mean, there's a whole variation, but most of the country has some degree of access. Where we're seeing the most restriction is in those, 12 weeks and beyond abortion on demand. That's where you see most of the restrictions occurring in these states that are the non-protective states. So hopefully that clarifies some of the issues surrounding this, and hopefully it gave you some information to think about or to consider. And certainly I hope I gave you a little bit of information that allows you to make good decisions for your own personal health. So, all right, well, thank you for listening, and we'll go back to our regularly scheduled playlist after this.